Welcome to the November 12th meeting of the Habeas Standards Work Group. We are going to pick up where we left off last time, and I will share my screen so that we can all take a look at what we've got going. We stopped right here where it is blue. So we're in the answering the respondent's case cross-examination type standards. Lawyers should be aware of the applicable law concerning competency of witnesses and admission of expert testimony to raise appropriate objections. This is one I assume you all deal with, the habeas standards. I don't know. Do you ever deal with whether or not witnesses are competent to testify kind of questions, or?
I really didn't. In my habeas practice, I did have some declaration testimony from other prisoners, but otherwise it's been my client and the medical people. That's that's been pretty much the gist of it, unless it was a declaration, it didn't come up.
Yeah, so is this from the criminal?
Yep.
Yeah. I mean, I haven't had situations regarding competency.
Yeah, it seems like pretty unusual in this context. So I'm not sure, like, really, I'm sure, like, it could come up. It's not like impossible that it would come up, but I just don't know that it's common enough that it belongs in the standard, especially like a.
Would it make more sense?
Like expert testimony makes sense.
Yeah. Okay. So what if we just pulled that? Lawyers should be aware of the applicable law concerning admission of expert testimony and raise appropriate objections. Does that fit better, do you think?
I think so.
Yeah.
Okay.
I mean, honestly, probably the admission of expert testimony is like not going to come up all that often either, but yeah, it's more applicable. So
before beginning cross-examination, lawyers should ascertain whether discovery laws have been complied with. If not, request at minimum adequate time to review documents before commencing cross-examination. This is another one we pulled from the criminal ones that I wasn't sure if they would apply, since discovery I know is different. But I didn't want to make decisions without running anything by you all.
yeah, I think that's appropriate.
Okay.
I think Tara would probably have thoughts on that too. Yeah. But I think leaving it in at least is good.
Yeah, I think it's fine to leave.
Good deal. Then we pulled the line about moving for directed verdict. Oh, sorry, go ahead, Ginger.
Is it discovery laws? That sounds weird. Is it discovery statutes?
Oh, it's the discovery rules.
Rules, okay.
I think that reads better.
I do.
Okay. And we pulled the bit about moving for directed verdict. So we can move on to closing arguments. Lawyers should be prepared to deliver a closing summation that presents the trier of fact with compelling reasons to render a verdict for the client.
I
Sounds
don't
good.
think it's called a verdict in it. I think it's just a judgment, isn't it? I don't think it's a verdict in
Oh,
a
that's good.
bench trial.
Would it be render a judgment or just render judgment?
I think it's a judgment.
Okay. Dropping down to our commentary. Familiar with the substantive limits on plaintiffs' and defenses' summations. Be familiar with the local rules and individual judges practicing concerning time limits and objection during closing. I think that was something we talked about, was that there were judges who would put time limits on things.
I mean, I haven't had one of these cases in so long. I'm not the right person to ask.
What?
I don't know
I
if they
had
put-
some. Oh, go ahead, Meg.
No, go ahead.
I did have some, sort of, we had this much time blocked out, so the
Yeah.
judge wanted to sort of limit, and also I did have at least one habeas where we did closing memo, like a closing argument memo, and I know we talked about that in the PCR, but I don't remember exactly how we worded it. But in my cases I had a while ago, we did have the opportunity to do a closing memo, and maybe less so time for an argument. I think I did one habeas case that was in person. All the rest have been virtual as well. So.
And I think that I agree with Ed that the time limits on closing is really based on whether or not you asked for appropriate amount of time for the case, to hear the case. So
Yeah, I haven't ever seen like specific time limits set for closing argument in particular. It's like a rush to get the case finished in time, perhaps, but
what if we say an individual judge's asserting objections during closing argument? There should also be. Oh, go ahead.
I don't know. I mean, does it matter if the judge wants or doesn't want objections during closing? Like, shouldn't you object if you should object?
I think it matters enough, and the reason I wrote it in that way is I think it matters enough that I would hope lawyers know what the individual judge prefers so that they can gauge their objections and the way they're objecting in ways that are not going to make the judge irate unless there's a need to do it. But ultimately, I think you're right. If you need to object, you need to object, and you need to save that for make your record and move on. But I think it's worth noting and knowing.
Yeah, I think it's any and always a preservation issue. I defer to Meg because she sees it more, but I think it's a preservation issue. If it's whether it's a bench or a jury, if you waive an objection, you might waive an objection, and the judges with the work we do, judges like us to lay down on stuff all the time, but it doesn't do the job we're supposed to do.
Yeah.
Yeah, I mean, to me, this just reads like, hey, if the judge doesn't want you to object, don't object. And I don't know. I disagree with that.
Okay.
I just think it should be.
Yeah, I also disagree with that. I don't think the judge is going to be they'll be the arbiter of the objection, but I don't think they should be the arbiter of whether or not you get to object. So I don't want it to read like that. Hey, Tar.
I also don't know if it's as relevant in this context of like, I mean, the objection and the preservation is still relevant, but where you have no risk of a jury, the like judge getting mad at you and the jury seeing that was sort of a different context. I wonder if it's just like making it a little less specific and just be familiar with the local rules and individual judges. I don't know.
I would just leave,
I think
Just local
I would
rules.
just do the red and leave it at that. But
That's fine too.
so. Pull this. Be cognizant of time limitations.
yeah. So Tara, we're talking about closing arguments.
Mhm.
And the only time limitation that Ed and I have come across is, not necessarily that the judge gives you 15 minutes for your closing. It's more that, if you haven't asked for enough time to hear your case or something like that, and you just run out of time. Have you had a judge say, Tara, you only have 15 minutes for closing?
Mm-mm.
I
Can't think of that. Yeah. I can't think of that happening. I've never had a time limit. I mean,
So maybe we just cut all of number 2 then.
I think maybe you can just put lawyers should be cognizant, or lawyers should, I guess, make sure that they ask for enough time.
Yeah, and I think we've got that earlier on in
Have
the
that
document.
elsewhere. Yeah.
Tara, are you okay with 2 coming out?
sure, yeah.
Okay.
If it's stated earlier to be aware of the SLRs, which it sounds like it is.
Mhm.
Yeah.
Yeah. And I know we have something earlier on about lawyers being aware of needing to ask for enough time for their case versus the delay in time it's going to take them to get longer hearings. So that was probably not phrased as eloquently as it is earlier
Yeah, I
on, but
understood what you meant. I don't think I was here for that, and I understood.
okay. Prepare outlines of the closing argument prior to trial and refine the argument throughout trial, reviewing the proceedings to determine what aspects can be used in support of the plaintiff's summation and where appropriate should consider all of that. Anything else we need to look at to add to that list?
What do you guys think about D2? Is that just instructing the court on this habeas standard? I don't understand verbatim instructions.
Yeah.
I don't either.
Yeah.
Criminal context, right?
Well, criminal and I think civil also, there are the standard instructions that you can ask be given.
For
I
juries.
don't know that. Yeah, for juries.
Yeah.
And I've used them in bench trials too.
Yeah.
Sure.
But I don't know that there are anything standard for habeas cases specifically. I looked and
No.
couldn't find any, but that doesn't mean there aren't any.
I don't think so.
Yeah.
You could just say the standards of review, incorporating into the argument the standards of review.
The standards of review for habeas.
Mhm.
Okay. Anything else on that list or that number that you all want to cover?
I don't
good.
understand 4, and I don't understand 5.
Oh,
Well, I understand 4, but
Sure.
does that really happen?
yes,
Okay. Okay.
it does.
Okay, how about 5? Should moot. What does that mean?
Practice in front of peers.
Okay. Oh,
Oh, okay.
I didn't see
I
it
did not
either.
understand moot being
I
used
didn't
as a
either.
verb. Okay.
I mean, it's a nice thought, but who does that? I mean,
I mean, it's great. I wish that could happen.
yeah, it would be great.
I guess it says whenever possible, so
Yeah.
it's never
And
possible.
this is our section on commentary of things that we think are good ideas, but may be impractical in most cases.
I think it's impractical because we're going to have been in trial day after day after day and preparing for the next day at night. And like, if you
Mhm.
write your closing before you give it, that's amazing. You know, that's like super primo, but like actually mooting it is not, there's just not the opportunity.
Do you think it is so impractical that mentioning it here is counterproductive?
Kind of.
yeah.
Yeah.
Okay.
I don't think people should have the expectation that this is something they should do when it's really not something they're possibly going to be able to do.
Okay.
I also don't want to have
It-
a standard in there or like a commentary in there, recommendation in there that like we know is not really practical and have that kind of color the other recommendations that we have that like are practical and you genuinely should do these things if at all possible.
Good
And
point.
then have one that's like, we know you're never going to do this, but we're just saying it for fun. I don't know. That
Does
makes
Yeah.
anyone feel strongly that we should keep it? Moving on then. All right. Takes us to 7.5. Consider the use of bench instructions, which if you all don't do and is not a thing, we can pull this whole.
yeah.
I haven't come across that, but like I said, I haven't done a habeas hearing in many years, so I don't know if this is a thing.
It's never come up in any case I've had or that I've heard about.
Yeah, same.
I've argued it, pattern instructions to a jury as persuasive, but I've even had a judge say, "Well, yeah, the jury instruction doesn't apply here." So I've argued them persuasively, but I can't recall or envision a situation where I'd be submitting the instructions, just arguing them.
True.
Cool. All right. So that's it for the 7s. So then I have a note about moving this one up to 6.1, and we can talk about that after we finish kind of the refining or before, if folks want to look at that in context. 6.1, too far. There we go. So moving the obligations concerning disposition to the sections on settlement. So it would be your obligations of disposition, your obligations to look at settlement, what you're obligated to do when you're entering settlement cases, as opposed to keeping it with the compliance monitoring piece.
It kind of goes in order. I mean, in terms of
Yeah.
the habeas,
Mhm.
the process of the hearing, it goes in order more here than, after closing and you're making your argument for disposition. In fact, I would say you could put it into closing. That
Okay.
might be a good place for it. So you want to make sure that you're specifically providing the remedy that you and your experts and your client want.
Okay.
Or you could just say up in 7, just say council should consider standard 8.1.
Mhm.
I mean, the answers to 8.1 should be included in your closing.
I like that.
I would make it a little stronger, not just consider, but council should provide remedies sought per 8.1 in their closing argument. I think it would be a big problem if somebody saw consider, but didn't actually think that that was necessary.
I agree. I mean, that's like, well, at least
Yeah.
my practice, that's the last thing you ask for. You restate
Yeah.
the remedy in your closing, but I agree with Tara that it isn't just consider. They need to argue it.
Okay. All right, so we'll do that. We'll leave this here. Any changes to the bolded font here?
I would say a lawyer must work with the client and experts.
Well, unless it's like a time calculation.
Right.
How
True.
about just plaintiff's team, which would tie in like investigators, legal assistant, expert witnesses, the whole
Mhm.
deal. Okay. Anything else?
So D, 1D.
Okay.
Where it's
Sorry,
talking.
before we drop down to the
Oh,
commentary
sorry.
stuff, anything else in the bold print?
I think it looks good.
Oh. All right, 1D.
Is this intended to be part of the trial memo, or is this separate from the trial memo?
It is not necessarily either one. So what I was trying to get at was that lawyers and their clients should develop a plan that seeks to meet the needs that necessitate the filing the habeas petition. So develop a plan with your client on how the case is going to go. That can be included as part of the trial memorandum. It can be included in other written documents, I suppose, but doesn't necessarily have to be.
I'm not really understanding.
Okay.
Is this something specifically for the client or something you would file?
For the planning stages of the case, so it does not necessarily something you would file.
This does seem like, or at least the commentary, I don't know, it does seem odd to have this at this point in the standards. It seems more
Mhm.
like
Yeah, that's a good point.
an initial how you get the case started kind of thing.
I think that makes sense to move that higher up. I'm not sure where, but we'll find a home for it.
So it's like an inner office memo.
Yeah.
Okay.
Although I don't know that it needs to be written down specifically. Just make a plan. I got on there too.
I guess, yeah.
I will work on that. Anything else about any of the things on this list?
I think E is stated as a standard earlier.
In the working with experts?
Mm-hmm. Yeah.
Yeah, I think you're right.
The rest looks good to me.
Okay. Anyone else?
I'm just, E kind of seems like that should go somewhere else, but I guess after you get the court's decision, then you should make sure,
Yeah,
I'm like a little confused by, this seems like a lot of different types of things to be considering, or like
yeah.
things that fit in at very different stages of the case. Like some are things
Mhm.
that you kind of should do from the very beginning, or at least before trial, and others like reviewing the judgment.
yeah.
She is definitely post-trial. And I guess I'm just not entirely understanding the framework of what the standard is getting at.
Yeah. And I think I wanted this to be something just to make sure we had all of this somewhere in here.
Yeah, okay.
Um, because
And I
some of
think
this was stuff I couldn't figure out where to fit in other places.
I think we have B somewhere else.
I think you're right.
Yeah.
And A
Let's
seems
make sure.
like we should have that in the very beginning.
Yeah, like 2.2 has like information that you should gather
Yeah.
about your client, which includes, yeah.
Yeah. Yeah.
Anything.
A is one of those we have throughout, but I felt like it was worth repeating.
So for D, it seems, and I don't know that it's commentary, it seems like if it said review the judgment,
Mhm.
ensure that the court did not consider. But that to me is not aspirational. That's something that
Mm-hmm.
Mhm.
should be black letter.
Okay. So what if we move that to black letter closing?
No, because you're not going to know that at closing. You're not going to know what the disposition is.
Mhm. But you would know what information is irrelevant or immaterial that's been presented.
That's a good point.
So we can move that there. We pull this
Concerning disposition.
section. And then just move these two over into their own 1 and 2. As far as our commentary goes. See what that would look like. See if my computer will do what I ask it to do. Yeah. So what if we just had that as commentary to the disposition language?
I don't know about two. It seems kind of vague. I think what I would just have is something like review the accuracy of the judgment, move the court to correct any errors that are incorrect, or just that, to correct any errors and file an appeal. I think that's
Okay.
In terms of those aren't really permissive commentary, but
It seems like, yeah, like that should be part of the black letter.
Yeah.
Okay.
But it's
we do have the undertaking of the appeal section coming up. That is in there.
So can we just put number 3 as a new sentence under 8.1?
Like that?
Yep.
Yeah, we can do that.
voila.
Okay. Lawyers must stay in regular contact with the client following disposition of the case in order to monitor the respondent's compliance with the judgment and must be prepared to resume litigation in the event of breaches. Lawyers' monitoring should continue as long as there is cause, but may be less frequent over time if pattern of compliance is established. Does that cover the general responsibilities after?
My only question is why are we going in between respondent and defendant?
Probably because I typed them at two different
Okay.
times.
I didn't mean that to sound rude. I mean,
No,
there
I
would have been
appreciate
a really
when
good explanation.
there could have been. There's not.
Okay.
I'm sorry, it's Wednesday afternoon and my brain just stopped. It is
Oh,
defendant,
that's
right?
me. Yes.
Yeah.
Okay. No, I always appreciate it when people point stuff like that out because it slips by me and then I end up having to review it at the end. So thank you.
Yes,
I
just
w-
put a note to yourself to review for respondent.
I would, the second sentence, a lawyer's monitoring should continue as long as there is cause, and the sentence there.
Mm-hmm. So cut that.
Yeah.
Okay. Everybody else okay with that?
Put a period after plaintiff's release.
Should there also be, if a defendant is non-compliant? I mean, there are like some steps before. I mean, you can seek release. You can also seek like compliance with the judgment.
Mm-hmm.
And it should be both, right?
The lawyer should seek to bring to compliance and should seek the plaintiff's release, something more like that.
I would kind of use the words that are going to trigger the pleadings. So I would say the lawyer should prepare and file a motion for noncompliance and contempt with a remedy including plaintiff's release.
Sorry, what were the words? Motion for,
Non-compliant,
Something.
for finding of non-compliance or contempt. And should request sanctions, including but not limited to plaintiff's release.
I think remedies, like plaintiff's release as a remedy, as opposed to a sanction.
That's how it's actually been done in my cases. It's
Which
been a remedial sanction in a contempt action. Yeah.
Okay.
Okay.
I think in White it was just a remedy for habeas.
I guess it's my last
Maybe in
case.
more
It
recent
was a
ones.
remedial, yeah, it was a remedial sanction.
Okay.
So you could say as a remedy or sanction.
Yeah.
Both will
Yep.
work. And that's the language, remedy is the language in White, the appeal. So that makes, yeah.
Yeah, I think that's the safer direction as far as like Court of Appeals decisions.
Mhm.
That's important.
so leave remedies or sanctions, or just,
Yeah, I think that's good.
Yeah,
It
that's
is.
good.
okay. All right.
Get those
Uh,
attorney fees
Yeah. Where do those go for appointed cases?
to my kids' braces. They go to me.
Okay.
And that's after years of back and forth, but they are ordered to me, and DOJ don't fuss with it anymore.
All right. And then here's my note about post-release compliance being something of a new area. And do we want to add anything about that?
I think a site like to White, and are there any other cases that have gone up? There will be by the time there will be at some point, but you could cite to White.
I think White cite the like federal case? I'm not sure it does. There was like a good federal, I think they're district court cases though. That provided or that required the prison to provide services and like a hotel room after release.
That was White. Yeah, they were provided, they were required.
Yeah,
Oh,
yeah,
it's
that was
Fox.
White.
It cites
Yeah,
Fox.
Fox, that's the one.
Fox is the district court case they cite.
Not.
If either of you have the actual case sites handy, that would be
I have
fantastic.
White. So White v. Raised 335 ORAP 124 2024.
REYS, Rays, RAYS.
REYES
And what were the
335 ORAP 124. And it's 2024, and I can get Fox too.
we can pop back to that one.
Yes.
Okay. Or if White cites it, I can pick it up.
It does not.
It's in the the final judgment, supplemental judgment, I think,
Mhm.
from White in Umatilla.
So then the preservation of issues for appeal. Lawyers should be familiar with the requirements for preserving issues for appellate review. Discuss the various forms of appellate review with the client and apprise the client which issues have been preserved for review and which issues may be appealed regardless of preservation.
I would add, because habeas has a very tight timeline for
Yes.
filing an appeal, that it has to be forwarded to whoever is handling the appeal, or, you know, gone to the next level for an appeal within no more than 30 days.
Yeah. And you can't fix it. So if you miss that 30 days, it's fatal.
It's horrible.
Back that down into the undertaking and appeal section. Back to that. All right. Anything else up here on either the bold or the commentary?
Not for me.
Meg, Tara, Ed, all good?
Yes.
Yeah. So
Yeah.
All right. In the very last section, the undertaking the appeal. Other than my flag on number 4, does anybody have anything they want to, and the timeline stuff we added, does anybody have anything they want to tack on to this one?
Can you go back up to the other one we just finished? I just feel like the second sentence of 9.1 and the first sentence of 9.2, aren't those this? Are they the same? Is it the same information?
They are pretty close.
I mean, discuss versus impart. I mean, it doesn't really matter. It just seems redundant, that's all. And throughout the
Let's take it out of 9.1.
Throughout the trial proceedings, that seems like preservation.
That is more geared at discussing with client than preserving for court.
okay.
Or at least it's supposed to be.
Oh, is this for the appellate attorney to talk to their clients?
No, this is the trial level attorney.
Excuse me.
Isn't it, Tara?
Thanks.
It's fine.
It's fine.
I agree.
Sorry, make say again.
Oh, I think that seems fine to me.
Yeah.
The way it's said.
All right.
For the timeline issue, one thing we just wanted to know is that you can refer, because it's such a tight timeline, you can refer a case for appeal before you get the judgment when you have it. If you have a sense that it's not going to go your way, or regardless, I guess, you can refer for an appeal, for an attorney for an appeal to OPDC. And so that way, and then just like make sure you send the judgment as soon as you get it. Which can just help with that really tight timeline. And generally, as the appellate attorneys in these cases, we prefer to file the notice of appeal as opposed to having the trial attorney or the client do it.
Mhm.
So we can make sure that it's correct and that we have it in time. And so if there are any deficiencies, those come to us instead of going to like the trial attorney or the client so that we can get them fixed in time.
Okay. You want to take that out then?
Yeah, maybe referring, like requesting a rehearing, referring for an appeal.
For number 2,
Mhm.
Tara, have you ever requested a rehearing?
You have to send me.
You can. Oh, okay. I don't.
Ah,
I'm not familiar with requesting a rehearing.
I don't think I've ever had requested a rehearing. A rehearing of what?
I'm not sure.
Yeah.
Is it like a retrial on a criminal case?
A redo?
Reconsider, motion to reconsider. I was
Motion.
Well,
to
I've done that.
figuring, but
Yeah.
I've done motions to reconsider. And that extends out the timeline.
Uh-huh.
I mean, I've had some judges say, that's not a real thing, Marion County, but it is.
So the motion to reconsider does extend the appellate timeline?
Well, they might change their judgment. It might not be a final judgment. Isn't that right, Meg?
Sorry, say it again.
If you ask for reconsideration, does that extend the appellate deadline? I didn't think it did, but I could be wrong.
If there's a final judgment, I mean, if they granted the reconsideration and changed it, that would, but I don't know that. Yeah, that does get complicated because then once you filed the notice of appeal, the trial court generally can't make major changes.
So probably safe to just file as soon as you have the initial judgment.
I think that if you think there's some reconsideration generally is also like the appellate courts have talked about not being sure they can review a decision for reconsideration. I mean, they could review it if you got a new judgment, but the like denial of reconsideration is something that the appellate courts are kind of iffy on whether they can even review that. That's a reviewable decision.
Really?
Yeah, as far as granted or denied. So I'm not sure. Yeah, I don't know. I'm not sure. Sorry.
So leave as is, or
I
take
think
out
ins-
the
I would
request for
take out
consideration
the,
language.
I mean, that's something you can do. I would take out the or and change it to and, so it's not, a choice between the
Gotcha.
two, and
I
just
think
make
that's,
sure.
yeah, the kind of thing where in your case, if you have a final judgment and you're going to file a motion for reconsideration, you should probably consult with an appellate attorney to see whether you need to file the no F now or not. And hopefully that appellate attorney will have a clear answer for you. Me.
Okay. So unless there's anything on cooperating with the appellate lawyer, stays. Is there anything comparable to a stay pending appeal?
DOC sometimes asks for stays pending appeal when they've lost and been ordered to do something. But I mean, generally in habeas, you're the plaintiff, so you're asking for the default to change. So if you've lost, there isn't really there's nothing to be gained by a stay of the judgment.
Okay. That was what I figured, but I didn't want to delete things without making sure. All right, so that takes us to the end of that. We got.
I mean, it is possible. I don't know if it's worth saying this. It doesn't come out all that often. But if DOC is going to seek a stay, it first has to do so in the trial court. So that's something that the trial attorney would need to litigate. And I mean, I think the trial attorney would probably understand this, but given the nature of habeas and the need for immediate action change, like if DOC gets a stay pending appeal, which appeals can take years, that kind of defeats the whole purpose of winning a habeas case. So that's an important thing. So you should litigate vigorously.
Great. So we'll tack that in at the end. And then we've got our meeting.
It's to stay the judgment pending appeal.
Oh. Great. All right, we've got our meeting Monday, and we will cover the differences between right to confine and conditions of confinement and make sure we've accounted for all of that. But other than that, I think we're in good shape. If anybody has,
can
yes.
email you those case sites for
Much appreciated. I think we've got White and we need Fox.
Okay.
Yeah. All right. And with that, I will see you all Monday.
Thank you.
Hi, everybody.
Thank you all for your work.